The case went to the CFI first and to the ECJ later on, and the court came in favour of the Commission on almost all points. Clearly, the approval by the National Regulatory Authority does not remove Deutsche Telekom responsibility for complying with competition law. And as the Commission said, Deutsche Telekom had the ability to terminate the infringement. The fact that there is a National Regulatory Authority decision does not mean that the Commission cannot act, and there were no errors in the methodology used by the Commission, and it was correct for the Commission to look at the cost of Deutsche Telekom and not competitors. The Commission lost on only one point, is the point about effect. The court said, no, there has to be, you have to prove an effect. But the courts didn't quash the decision because the court recognized but the Commission had done their job by actually looking at the effect that the conduct by Deutsche Telekom had on the market. Telefonica was the next. Again, the Commission, the use of equally efficient competitor, which you've heard earlier on. There was a very detailed analysis of losses, of all the losses that Telefonica was making each year. Because Telefonica was saying, it is true I'm making losses, but this is a new market, this is a new product. It's very normal when a company launches a new product that there are initial losses. But I know that later on I will recoup all those losses because, I'm growing the market, new customers will come in, and I'm planning to sell other services on my broadband services. So there's a very detailed analysis by the Commission whether those initial losses would be covered by future profit over a 5-year period, which is the sort of the lifetime of a customer. And what they used is a very detailed economic method, discounted cash flow, which I leave my colleague economists to explain more in detail. The Commission also said this is not a mature market, so the fact that you're making losses is not a justification anymore. And like in Deutsche Telekom, there was some intervention by the NRA, the National Regulatory Authority, but it wasn't as intrusive as in Deutsche Telekom. But more importantly, the Commission found internal documents that clearly stated that Telefonica knew that its retail arm was operating at severe losses. So this one, the case is actually, Telefonica is currently, as I was saying, appeal. The hearing was about a month ago, and as we will see when we talk about Tilia Sonera, if I were the in-house lawyer at Telefonica, I wouldn't keep my hopes high of winning the case. Now, before I move to Tilia Sonera, we discussed earlier on the guidance on enforcement priority. And somehow it seemed that the Commission had come to a conclusion about what margin squeeze was. First of all, it was clearly acknowledged it was nothing but a form of a refusal to supply. So the burden on the Commission to prove an infringement was quite high because they had to prove the usual requirement in a refusal to supply. The input must be necessary. There must be elimination of effective competition. There must be consumer harm and competitors excluded. And there must be no efficiencies. Tilia Sonera comes in at the beginning of this year. It clearly states that the test is not so stringent. And here it is. The facts are very similar to Telefonica and very similar to Telefonica and Deutsche Telekom, with possibly two exceptions. This was a national case, and it went to the Stockholm court, which referred questions to the ECJ. And more importantly, not all the wholesale products which were provided by Tilia Sonera were regulated. So here, there was not even a regulatory obligation to supply. Tilia Sonera had decided independently to supply certain products. And the question the National Court asked was exactly the questions lawyers were asking, if you remember, at the beginning of the year 2000. And that's why I think it's a very, very interesting case. I'll skip that slide and just move to what are the key points. First and foremost, margin squeeze, it's an abuse in its own right. It's not a form of refusal to supply. And it's interesting the justification for that, because the court recognizes that since margin squeeze is difficult, if it was a refusal to supply, such difficulties would unduly reduce the effectiveness of Article 102 as applied by the Commission. Test, we've seen it in the previous cases, recognize its equally efficient competitor. with a but. If you read paragraph 46, but exceptionally those of our competitor. And actually the court says, for example, in cases where the cost structure of the dominant company is difficult, then you do look at the cost of another company. But for example, there might be other cases where the dominant company has a first mover advantage, has got such big economies of scale that actually you cannot look at that. You have to look at the cost of a new entrant or another party. So clearly the test has become much more fluid because, again, as we were hearing before, if you're a dominant company, you know your own costs. You cannot and you shouldn't know the cost of your competitors. Again, effects. If you remember Deutsche Telekom, the court said there has to be effect. Here the court dilutes much heavily what effect means. First of all, as they say, concrete or actual effects are not necessary. The point is that it's sufficient to demonstrate that there is an effect we may potentially exclude. Now, potentially, in my view, is almost a per se abuse. We're going back to where we were previously. And they continue by saying, if the margin is negative, as I was saying before, 150, an effect is probable. And you can see why. But actually, even if the margin is not negative, so 105, 110, there might be an anti-competitive effect, but the Commission has to do more, so they have to prove the effect. Indispensability is one I found quite hard to digest. There's no need for the product to be indispensable. So in theory, as a competitor, you could find your wholesale product somewhere else. But notwithstanding that, if there is a dominant company that has certain obligations, and so indispensability is not part of the analysis. It's not necessary, but it's actually part of the analysis of the effect. So if the product is indispensable, the effects are probable. But even if the input is not indispensable, there might be anti-competitive effects. And then there's various discussion about the degree of market power. So to recap, as I say, these are all the questions that the court answer. For example, there's no need to have dominance on both upstream and downstream market. The fact that the dominant company is unable to recoup losses is irrelevant, etc., etc. So what actually is important here is, remember, there was no obligation to supply, neither under regulation. So if a vertically integrated company chooses to supply, what this case tells you is you have to set up your price at a level which doesn't squeeze competitors. And I thought I would contrast this with the US approach, because as we know, there's been a lot of debate between the differences about from the US and European approach to abuses of dominance. But this is possibly the most obvious as far as I'm concerned, because the facts of the case are exactly the same as Deutsche Telekom. I'm not going to go in detail about the case, but again, you have a wholesale supplier of internet service, a retail buyer which supplies to end consumers. And it went all the way to the Supreme Court, so clearly it has some relevance here. And the 2 points that came out of the judgment are, first, there cannot be a price squeeze claim if there is no antitrust duty to deal. In this scenario here in the US, there was a duty to deal under regulation, but the court here said this is different. Only if there is a duty to deal under competition law, something could be construed. The only option which is left in that scenario is there is a predation downstream. But here, the party didn't discuss that. But what then the court says is, if both the wholesale price and the retail price are lawful in itself, there is no basis for imposing antitrust liability simply because the wholesale price happens to be greater than or equal to its retail prices. And there's actually a quote from the judgment which I always like. Plaintiff's price squeeze claim, looking at the relation between retail and wholesale prices, is thus nothing more than an amalgamation of a meritless claim at the retail level and a meritless claim at the wholesale level. So you can see very clearly what difference it is between the US approach and ours. So what I want to say here is just, I think Tillerson has clarified I wanted to conclude with just a few thoughts. Tillerson has clarified what margin squeeze is, but actually it has made it much easier for authorities to find an abuse of margin squeeze and much more difficult for dominant companies which are vertically integrated to set their own internal prices. There are still several issues to be resolved. This case has clearly been, all the cases that we've discussed so far have been in the telecom sector, but the principles are applicable to a larger amount of cases. There's actually one I can think of in the UK which deals with pharmaceuticals. So clearly there's some scope for expansion here, and I know that most national competition authorities are clearly expanding the concept of margin squeeze in various jurisdictions. And that brings me to the other point, which is how will national competition authority apply the rules? We're seeing a plethora of cases. They've been mostly in telecoms so far, but as I said, we'll watch and see. But more importantly, only after 2 years, the Commission guidance already has been sort of tarnished by what the Court of Justice has said. So bringing back to the point you were making, is what's the value of that guidance? If already on one point we thought was sort of clear, difficult to address, but clear, that has disappeared. As I was saying before, Telefonica, let's see what happens. This is a full appeal. Let's see what happens, but I wouldn't keep my hopes high for them. And then I wanted just to touch very quickly the differences with the US as a useful comparison. And that's all.